Nevertheless, in yet another 5-4 decision, the conservative majority on the Roberts Court held that partisan gerrymandering presents political questions that were beyond the reach. And here I will just pose to emphasize the problem that the court saw, okay? If you want to draw your lines for where legislative boundaries should be on the basis of race, that's not permitted in any degree, right? The 13th, 14th, and 15th Amendments have been interpreted to understand that racial-based drawing of lines is not permissible in any respect. So you can't do it for one person or 10,000 people or 100,000 people. You cannot draw the lines based on race, okay? But here's the problem with partisan gerrymandering. The problem is that the Constitution gives the power to the legislature to draw the lines, which of course is an inherently political body. So the entire process is inherently political ab initio from the beginning. So politics are unavoidable. And so if you take the position that the legislature can't use politics at all to draw lines, you're like, what does that even mean? Because the legislature is political. That's all they do. The legislature is political. So to say they can't use politics in drawing the lines, it's like, or that doesn't make any sense. So they can do it to some degree. The problem is trying to find out the difference between a legitimate degree, whatever that might be, and an illegitimate degree, assuming one exists, and how you define the difference between the two. That was the problem. The court couldn't figure out. The court in its case law had sort of mused in dicta over about 20 years. The court in its case law for about 20 years had mused. It is possible to do it to some degree, and it's also possible to do it to a degree so far that it would be unconstitutional. And the court for 20 years said, please help us figure out the difference, and no one could. So that's basically the challenge. Nuvi gives me $5 and says $5 for ad block. Thank you, Nuvi, very much. The majority's rationale for reaching this result was what the court could not find a discernible and manageable standard. They couldn't find a judiciable standard for deciding when gerrymandering was so partisan as to be unconstitutional. Exactly, that was the rationale. Justice Kagan's dissenting opinion made clear how weak and unsatisfactory the majority's justification was. But in throwing up its hands, the majority misses something under its nose. What it says can't be done has been done. Over the last several years, federal courts across the country, including but not exclusively the district's decisions below, have largely converged on a standard for adjudicating partisan gerrymandering claims. The standard that they had come up with was very amorphous and very floaty and very open to interpretation. And when it comes to voting district cases and how these lines are drawn, the Supreme Court is in a unique position in terms of how it hears these cases. Okay, that also creates a problem. So in your normal run-of-the-mill average case, when someone is suing someone else, right, in federal court, what you normally do in your average run-of-the-mill court case is you start in district court with one judge who hears the case and does all the fact-finding, etc. Then you have an appeal as a matter of right to the Court of Appeals, which is the 3-judge panel, and then you can also ask for en banc, if you want, which is the entire court to sit, all the members of that circuit. And then you can further appeal from there on a writ of certiorari to the Supreme Court. So in your average run-of-the-mill case, the Supreme Court wouldn't be worrying about it that much. They wouldn't be worrying about too much about, them not having a standard or it being a little bit shaky or whatever. Because one of the things the Supreme Court could do in your normal average run-of-the-mill case is let the lower courts figure it out, which is one of the reasons on which they take cert in the first place, is to settle disputes between the circuits. So one of the things they can do is say, well, we're not really sure what the standard should be, but we have a solution to this problem. We have a solution to this problem. Fortunately, we have 12 numbered circuits if you count DC, which you really should for the purposes of this exercise. We have 12 regional circuits. And what we can do is we can let each of them figure it out separately. So they can all argue amongst themselves for, the next 10 years or 20 years. And, they can have different panels and en bancs and blah, 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 blah. And they can all look at each other and sort of, compare notes with each other and look over each other's shoulders and copy and disagree and all that stuff, right? And so, like, once they have done that for a while, then what we, the Supreme Court, will do is use one of the classic grounds we have to settle a split of authority and resolve the problem. But fortunately, all these lower courts have already done all the groundwork for us. So we can now look at all the groundwork they've done, and we can go like adopt one of those or modify them, whatever. We don't have to figure it out in the first instance. We can make them do it. Right? Okay, so that's your normal run-of-the-mill case. Why can't you do that in this case? Why can't you do it when it comes to voting district lines? Why can't you do it when it comes to how states draw the district lines? Why can't you just do that normal process? And it's because by law, by federal law, the normal process is not the process you use in voting district cases. The normal process isn't the process you use. The process you use in voting district cases is you file at trial court, but the trial court is a 3-judge court. The trial court is a 3-judge court. Okay? Don't ask me to explain it. I'm just telling you what it is, okay? So in voting district cases, when you file in district court, and you get a 3-judge court. And then you have a right to appeal. So to the Supreme Court, which is much different than a writ of certiorari. A writ of certiorari is discretionary. The Supreme Court has the right to say no. And they say no quite a lot to a writ of certiorari. But they can't say no to the appeal because they are the appellate court. They are the appellate court by law. They are the court of appeals. So they can't say no. And because they're the only court of appeals, there's no like lower courts to help like rough and tussle and like, battle it out and all that stuff. There's none of that to do. So all the Supreme Court can do is look at itself because there's no one else. It's just them. Because all districting cases are done this way. Because Congress said it's law. It's in the jurisdictional statutes. It's in the jurisdictional statutes. So when you're doing voting district cases, you can't, as the Supreme Court, say, well, what did the Court of Appeals do? Because it doesn't exist. You are the Court of Appeals. So you're the one who has to come up with this standard for the entire nation. You're the one who has to create this standard. And because every one of these cases can be appealed directly to you, and you can't say no to any of them, that means whatever standard you come up with has to be so easily understood that none of these appeals will go anywhere, right? You have to come up, because remember, you're appealing from the district court. And I don't even remember how many district courts there are. There's like 140 of them, when you count like all the district courts in all the states. 138 maybe, something like that. So you're going to have 138 appeals potentially every year on these cases. The Supreme Court can't deal with that. The Supreme Court can't deal with that volume. The Supreme Court can't adjudicate every one of those 131 cases. They can't do it. They just don't have the bandwidth to do it. So the only way for them to do it practically is to come up with a standard that is so objective, so clear that, even a trained monkey could do it, right? And that way it becomes really, really easy. Because then it's just that the district court do the trained monkey thing. They just plug in the numbers into the equation so we don't have to consider these all the time. That's the problem. That was the problem the Supreme Court was trying to solve. So yes, the courts that have been dealing around with this stuff had come up with tests. The problem was the tests they came up with were really, really floaty and really, really discretionary and really, really sort of subject to judgment. And you say, well, what's wrong with that? What's wrong with standards that are really just subject to judgment? Isn't that good? Well, it's not so good when you're the U.S. Supreme Court and you're the Court of Appeals and you have to administer all these really, really floaty standards. And incidentally, by the way, lest I have to point out the obvious, if you're striking down a map, a politically drawn map, okay? You're striking down a politically drawn map. People are going to accuse you of politics, right? People are going to accuse you of politics. The courts don't do politics. The courts do law, right? But if you take a map and say, this map sucks, let's replace it with this other map that we created out of nothing, people are going to say, hey, you're playing politics. You're not supposed to do that. So the only way the Supreme Court can avoid that problem, is to come up with a test that is so clear, so objective, so easily administratable, and so unsubject to the whims of whoever's looking at it, that no one can accuse them of playing politics. It has to be an equation that you plug the numbers in and the result comes out, and that's the end of the ball game. That's the only way this works, because the Supreme Court is going to be striking down political maps. So the only way for them to administer this, the only way for them to strike down maps, the only way for them to create entirely new maps, and for people people not to be able to say, well, this is just politics, this is just political, they're doing it to favor the Democrats, or they're doing it to favor the Republicans. The only way the Supreme Court can be able to do all that with any sort of reliability, the only way they can do that is to have an equation that is so easy, a trained chimp can do it, and then it's like, aha, it's not politics because it's just the equation. That was the problem they were trying to solve. They couldn't do floating. They couldn't do discretionary. They couldn't be do something like, well, if you look at this way, or if you look at this way, then maybe it's this result, or maybe it's this result. They couldn't do that. Because then, depending on who's on the Supreme Court at any given time, the results are going to be different. So there's no dependability. As members of the court come and go, different courts are going to be coming up different results on the same facts based on the same exact tests, right? Because they're judges. They're judges. So as members of the court change on the same exact facts, they come out with different results. Now, that's not normally such a big deal, but it's a little bit of a deal when the issue at hand is, does this political map, should it exist? And if not, should we create a different political map? And we, the court, are going to create a new political map, and we want people to not think it's political. That's asking a lot, man. It's asking a lot. All right? So the only way I can see for that to possibly work, to create new political maps that are not perceived as political, the only way I can foresee that to work is we have something that's so dead simple, so objective, so clear, so unambiguous, that no matter who's on the court, no matter who's applying it, the result always comes out the same. Like a mathematical equation level of certainty. On the same facts, it always comes out the same. And the Supreme Court couldn't do it. They couldn't come up with something that clear. That was the problem. Okay? That was the problem they were trying to solve. That was the situation they were dealt with. They were dealt with a posture. That put them into a position where if they're going to do this, it has to be so unambiguously clear that no one can doubt them. That was the problem. They're looking to the long-term legitimacy of the court. They're looking to make sure the court isn't perceived as political, because once the court is truly perceived as political, it's game over. And if we're going to strike down political maps and not be perceived as political, well, we need something super, super clear so that it doesn't matter who's doing it. That was the problem. And yes, I'm a little heated. Unicorn Cupcake. I'm a little heated because this judge, either it doesn't understand the problem, which I don't begin to believe for 1 second, because there's no way you can be a sitting federal judge since 1990 whatever and not be aware of the problem, or is not explaining the problem, or is being very disingenuous about the problem. It's impossible. It's impossible. If the court had gone the other way, and adopted the really, really floaty standards, then the Democrats would be even more irritated than they are now, because the Republicans, who are currently in control of the court, would then be using this really, really floaty test to create maps that would be perceived as Republican, and vice versa, depending on who's on the court. The institutional legitimacy of the court was on the line. Courts don't do politics. Courts do law. Right? So if we're going to do law and not do politics, and we're going to strike down political maps, and we're going to create new political maps, and not be perceived as political all at the same time, well, that's asking a lot. So the only way we can do that is for it to be completely objective, 100%, no discretion, very, very clear, and they couldn't do it. They couldn't do it, and that's why the test that had been created by these lower courts that were really, really floaty. Oh, it had been agreed upon. The Supreme Court couldn't do it. The Supreme Court couldn't do it. They couldn't adopt it. It was completely unadministratable in a way that would have allowed the court to be legitimate. Completely unadministratable. So, like, it had to be that way. It had to be that way. So it really irritates me. Really irritates me. Because once you understand the posture of the Supreme Court, once you understand the mechanism of the Supreme Court and how this works mechanistically in terms of these cases getting before the Supreme Court, once you recognize that they have to hear every one of these redistricting cases, they have no choice, they have to do it. Once you realize that, it's like, what else can you do? And clueless beekeeping comes at me with a rejoinder. Clueless beekeeping comes at me with a rejoinder. Says, sorry, Bob, but the court does do politics in the real world. Okay, clueless beekeeping. I accept your premise. The court does politics in the real world. All right, so here is your question then. Is that good or bad? Is it good or bad that the court does politics in the real world? If it's good that the court does politics in the real world, if you think the court should do politics in the real world, then it would be a good thing for the court to do politics. Therefore, this decision was wrong, because the court could have done more politics, and it would be good for the court to do politics. So the court should have come out the other way, because it would be good for the court to do politics. If, on the other hand, you think that it's bad for the court to do politics, then even if you accept the premise the court is already doing politics in other cases, it would not be a good thing for them to do politics in this particular instance. We should, if anything, roll it back so they're doing less politics, not more. So even accepting the premise that they do politics currently, unless you think it's good, this decision was correct.